Hi, this is Michael Sandler with Fisher-Sandler, continuing our myth series of bankruptcy videos. So myth number 2, if I file bankruptcy, I'm going to lose my house. Don't think that. There's no reason why you should lose your house in a bankruptcy case. What happens if you own a house? Well, we'll look carefully at the situation and see if filing a Chapter 7 is a possibility or if we need to file a Chapter 13. Chapter 7 is known as liquidation, and that's when you're in and out in bankruptcy, typically in 3 months. You get rid of your credit card bills, your medical bills, that sort of unsecured debt. When you file a bankruptcy case, about a month after you file, you have a meeting with a court official called a trustee. And the trustee's job is to see if he can take any of your stuff to sell it, including your house. Now, in Virginia, where we practice, you have a $25,000 exemption to protect equity in your house, and you have a wild card exemption for $5,000 that you can also use. Now, the house has to be your primary residence to utilize that $25,000 exemption. So I just want to make that caveat. But let's say your house is worth about $400,000 and you owe about $350,000, and you're saying, oh no, I have $50,000 in equity. That means I'm going to lose my house because you said I could only protect $25,000. Well, the trustee has to sell your house like anyone else. That means he has to hire a realtor, pay the realtor fees, the closing costs, that type of thing. So if you take that $400,000, you subtract your $30,000 in exemptions, and subtract, say, another $30,000 in sales costs, there's really nothing left for the trustee. And we need to make sure what your house is worth. I don't suggest that you pay $500 for an appraisal, but you do need to talk to a realtor in some cases and ask for a market analysis, so we can get a realistic view of what your house is worth. Now, that is the situation if you own the house by yourself. If you own the home with your spouse, in Virginia, there's also the possibility of having what's called the tenants by the entireties exemption. And what that means is that if you own your house with your spouse as tenants by the entireties, and you don't have any joint debt with that person, then the trustee can't touch the house, and it doesn't matter how much equity is in it. It doesn't matter if you have $500,000 in equity. The trustee still can't touch it. He can only sell the house to pay joint creditors. Now, the IRS is in that list also if you file joint tax returns, so be careful about that. But if you own your home with your spouse, which typically gives you the best protection in Virginia, then you have that exemption as well. Now, let's say that we are worried about actually losing the house in a Chapter 7 case. You can still file a Chapter 13. Chapter 13 is when you're doing a payment plan to pay back a certain amount of your debt. Not necessarily all your debt, but some percentage. And it's typically 3 to 5 years. In a Chapter 13, you keep all your property unless you want to surrender it. Now, there's a lot of rules in Chapter 13 on what your payment has to be. But if I have clients and I tell them, I don't think you're going to have an issue with the house in a Chapter 7, but they're still uncomfortable, worried about the house, which is most people's primary asset, then I tell them, well, then you can file a Chapter 13 and you got nothing to worry about because you keep your property in a Chapter 13. So that's also a possibility on a way to go. But if you have an experienced attorney that can look over the situation and understand the exemptions in Virginia and the rules, then there's no reason why you should lose your house in bankruptcy. So if you are concerned about your house, feel free to make an appointment to talk to one of us about this, or watch other videos for more information if you have more questions. Hi, this is Michael Sandler with Fisher-Sandler, answering your quick bankruptcy questions with quick answers. So one question that comes up from time to time. Hi, this is Michael Sandler with Fisher-Sandler, answering your quick bankruptcy questions with quick answers. So one question that comes up from time